From theory to action, how contracts are actually formed. Now that we understand the legal elements of a valid contract from Section 1.2, we move into how those elements come to life in real-world commercial transactions. Contract formation is not a single event, it is a process. It begins with an offer, evolves through negotiation, and becomes binding upon acceptance. In commercial real estate, this process is often more dynamic, strategic, and complex than anything seen in residential deals. Formation is where deals are won or lost. It is also where many agents unknowingly create risk for themselves and their clients. Understanding how offers, counteroffers, and acceptance operate under Arizona law is critical to ensuring that your contract is enforceable and your client is protected. The offer, starting the transaction. An offer is the first step in forming a contract. It must be clear, definite, and communicated to the other party. In commercial real estate, offers are typically detailed and may include pricing, financing terms, due diligence periods, tenant requirements, and contingencies. For example, a buyer submits an offer on an industrial property in Phoenix that includes a 60-day due diligence period, environmental inspection contingency, and financing approval. This is not just a price. It is a comprehensive proposal outlining how the transaction will proceed. Under Arizona law, the offeror controls the terms of the offer, including how and when it can be accepted. This becomes critical when dealing with deadlines, expiration times, and method of delivery. Counteroffers, where negotiation happens. In most commercial transactions, the initial offer is just the beginning. The seller will often respond with a counteroffer, modifying key terms such as price, timelines, or contingencies. Here is where many agents make mistakes. A counteroffer is not an acceptance. It is a rejection of the original offer and the creation of a new offer. This means the original offer no longer exists unless it is revived. Consider a scenario where a buyer offers $3 million for a retail center, and the seller counters at $3.2 million with revised terms. If the buyer then responds by changing the due diligence period, they have not accepted the counteroffer. They have created another counteroffer. This back and forth continues until both parties agree on identical terms. Failure to understand this concept can lead to confusion about whether a contract even exists. Acceptance. When a contract becomes binding, acceptance occurs when one party agrees to the exact terms of the offer or counteroffer without any changes. This is the moment a contract becomes legally binding. Timing is critical. Under Arizona contract law, acceptance must occur before the offer expires and must be communicated according to the terms of the offer. If an offer requires acceptance by 5 p.m. on a specific date and the response comes after that time, the offer has expired. In commercial real estate, acceptance often involves multiple signatures, entity approvals, and delivery requirements. Agents must ensure that acceptance is properly executed and communicated to avoid disputes. The importance of clear communication and documentation. As emphasized in earlier sections, documentation is everything. Under ARS, paragraph 44101, all real estate agreements must be in writing to be enforceable. This includes offers, counteroffers, and acceptances. Additionally, AAC R428-1101 requires agents to exercise reasonable care in communicating information. Miscommunication or failure to properly document negotiations can lead to serious consequences. For example, if an agent verbally communicates acceptance but fails to deliver a signed contract, there may be no enforceable agreement. This is a common issue in fast-moving commercial deals where parties rely on email or verbal confirmations instead of properly executed documents. Case law and real-world risk. Arizona case law continues to reinforce the importance of clear contract formation. In Jennings v. Lee, the court highlighted the fiduciary duty owed by agents, including the responsibility to ensure that agreements are properly structured and understood by their clients. In a commercial context, this means agents must go beyond simply transmitting offers. They must ensure their clients understand the implications of the terms being negotiated. For example, negotiating a shorter due diligence period may make an offer more attractive, but it also increases risk for the buyer. Failing to explain this could be seen as a breach of fiduciary duty. Real-world breakdown, when negotiation goes wrong. Let's walk through a common issue. A buyer submits an offer on a multi-tenant office building in Scottsdale. The seller responds with a counteroffer, which the buyer signs but also makes a minor change to the closing date. The buyer believes they have accepted the deal. However, because the buyer changed a term, this is not an acceptance. It is a new counteroffer. The seller never signs this version, and later accepts another offer from a different buyer. The first buyer believes they had a contract and threatens legal action. In reality, no contract existed because there was never true acceptance of identical terms. This situation could have been avoided with a clear understanding of contract formation. Connecting to the next section, now that we understand how contracts are formed through offer, counteroffer, and acceptance, we are ready to move into how these agreements are structured within the commercial purchase contract itself. In the next section, we will begin breaking down the actual contract language and provisions, showing how negotiation translates into enforceable terms on paper. Online discussion. Why is a counteroffer considered a rejection of the original offer? Answer. A counteroffer changes the terms of the original offer, which legally rejects it and replaces it with a new offer. The original offer is no longer valid unless it is reintroduced and accepted. What is required for acceptance to create a binding contract? Answer. Acceptance must be for the exact terms of the offer or counteroffer, must occur before expiration, and must be properly communicated according to the terms of the offer. How can poor communication during negotiations create legal risk? Answer. Miscommunication or failure to document agreements can result in disputes over whether a contract exists, potentially leading to lost deals, legal action, and disciplinary consequences for the agent.